So the last thing that I generally talk about with a client in that initial consult is the representation agreement. And if we have both determined that the relationship is going to be positive and needs to go forward, I will get a representation agreement that I have worked on for about 12 or more years. And in that representation agreement, I outline what the scope of work is, what the client is hiring us to do, what problem we are being hired to solve. And generally limit it to that and no other matters, because especially with business clients, other things tend to pop up, but that may not be exactly, if one thing's a litigation matter and then another issue is just corporate records, corporate books and records, may not want that in the same representation agreement for reasons that your CPA might want, for corporate form bookkeeping, just having better bookkeeping, better record keeping for business clients. But sometimes out of necessity, that just does happen. But generally I recommend scope of work limited to the problem being solved for here. Anything else will be a separate representation agreement, even if it's just a representation agreement with a new scope of work, and continue on as attorney-client. But in that representation agreement, I set out some specific requirements that the state bar wants all attorneys to talk about, and I want clients to have that conversation at the beginning of the representation instead of during the course. And in there I talk about what the billing rate will be, what it's going to cost to retain the attorneys in the law firm, what it's going to cost to have the staff work on the cases, what it's going to cost for pre-trial litigation. Remember those copy costs I talked about in a prior video on this series, compartmentalizing your life, photocopying it, making a copy for every person in the courtroom. Those costs are in that initial consult, and they're in the representation agreement, so that way the client is aware of them on the front end and not surprised by them. Disclosures about what trial costs are projected to be, and that's just a budget. Those things can tend to go up. Trials can run longer than anticipated for many reasons. And then other things about expenses that come up along the way, expert witnesses, investigators, etc., and that the client will be expected to pay for those litigation expenses. Not that you'll ever be surprised by them, but I always tell clients you're going to be expected to pay for them. And there's a few other things as well, and I'll jump into those in the next segment.